go on to the articles that we haven't gotten to yet. So the first one is Article 16, which is to authorize the Board of Selectmen to amend the agricultural provision restriction at 6668 Boston Road to allow the construction of a restaurant. This is a citizen's petition. So I don't know if there's anything more that the petitioners would like to share with us.
Yes, we are.
Okay.
Good evening.
Come on forward. Just let us know who you are.
Susan,
Maybe
Susan can sit. Is there something?
Yeah,
Just so
Susan,
they
can you
can.
let these guys sit at the table there?
Thank you.
And
Maybe we can find a chair for her.
I'll stand.
That's okay. It's okay. We'll need it later.
Susan will find a chair.
Yeah, let's get a chair.
Those chairs must be valuable that they're locked up. We have a theft
Came here last night to get some chairs.
chair theft problem.
We just slide down one.
Yeah. Everybody slide.
Oh, sorry. I wasn't-
Oh, yeah, slide around. That's
Okay,
good.
we're all sliding now.
Okay, all right, here I go. Actually, you know what? You can say we are. I'm going to move around the corner.
Okay.
How's that?
Okay.
Government in action.
Okay.
Okay, they're all, now that I've reorganized this all. Fine.
Okay. I think we're all settled.
Good evening, Mr. Chairman, members of the board. My name is Mike O'Neill. I'm a lawyer with the firm of McGregor and Legere in Boston. We're environmental and land use attorneys. We represent the petitioner. As you probably know, these three parcels were acquired in the late 1990s. The APRs on these three parcels were acquired in the late 1990s over a 3-year period, over 3 fiscal years, hence APR 1, 2, and 3. It's 8.97 acres purchased by the town with town money, no state funds, no state program. And APR 3, which we're concerned with today, specifically by its terms, allows a country store on the property. Now, it's very important that APR 3 gives the administration of the APR to the selectmen, to you, to the board. And the enforcement of it is in your discretion, in your sole discretion. It's up to you to decide how to enforce it or not. Now, it's also very important that there has been no farming on this property for more than 10 years. So this amendment is to restore agricultural use to APRs 1 and 2, and this warrant article is expressly conditioned upon the fact that the agricultural use on 1 and 2 be continued, and that any approval of the farm-to-table restaurant will be conditional upon APRs 1 and 2 being continued in agricultural use. So, to summarize, this is to restore agricultural use to this property, which is, and it's a win-win situation in our opinion. It'll restore this to the productive use, to the giving the town some tax revenue. It will restore the original purpose of the APRs, which is to promote agricultural use. The choice is now just to leave it fallow and desolate, not doing anything, as opposed to restoring the agricultural use and having a nice restaurant. Meanwhile, Mr. Halajan has agreed to pay the town back the $175,000 that it paid for the APRs, with interest. Again, it's a win-win situation. Now, we have submitted letters to the board back in 1997, and we continue to again assert that there's no Article 97 issue here, because there is no disposition, there's no release of the agricultural preservation restriction. An amendment is not a release. We've laid that out in some detail. An amendment is not a release. Similarly, there's no requirement of a 2/3 vote for a town meeting. The statute says that there are certain very specific items that require a 2/3 vote, and this is not one of them. This is not an exchange of property between town departments. So if anybody has any questions, I'd be happy to answer any questions.
So what I'd like to do to try to manage this is first start with questions, both questions here and then questions from the audience before we get into opinions and views. So I'd really like to get the questions out first. So let me start from the board, if anybody's got questions in relation.
I have one clarification to what you said, and that had to do with that there's been no farming there in the past 10 years. They have been, before the most recent owner, the previous owner was growing potted landscaping plants, which is an agricultural use, and the field used to be covered with blooming mums late in the summer. So that is, even though that wasn't in the ground, that is an agricultural use and has happened within the past 10 years.
Okay. Other questions?
Not a question, it's a comment, but, it's not a case of either there's a restaurant or there's no farming. I mean, there can be, the way you phrased it was, we have to have a restaurant in order to have APRs 1 and 2 farmed. That's not actually what the agreement was back originally, 2016, which was that if APRs 1 and 2 are farmable, if the restaurant were to not be accepted by the town, APRs 1 and 2 are still farmable. So I just want to be clear that there's not an assumption here that it's either or.
Right, right. The agreement in 2016 provides that the APRs remain in effect.
Right.
And
That's what I just wanted to clarify.
Point of clarification, like Elizabeth's point of clarification, yeah.
So it sounds like there's a question of whether Article 97 applies, and then there's more general discussion. Are you going to take those up separately or together?
So a couple of things. First, as it relates to whether it's 2/3 or a majority, I want to defer that particular point to the motions meeting that we're going to have tomorrow. Okay, so as it relates to tonight, and we'll kind of get that answer. But whatever questions you have, Tom, it's whatever.
I guess I appreciate the information that you wrote earlier this week and shared. Just one more time, can you let me know explain when Article 97, according to the statute, the words in the statute, when that should apply?
Sure. So, Article 97, protects certain lands that are in agricultural conservation or recreational use, and in order to, according to the statute, in order to release an interest in such a land or to change its use, you have to comply with the procedural requirements of the Constitution and the Secretary of Environmental Affairs. So the key is, would this action constitute either a release of the town's interest in the APR, or is it a change in use away from the original purpose of the APR? If either of those questions are answered yes, then the procedural requirements of Article 97 apply.
Okay, and we have opinions on both sides about whether this is a change in use.
That's correct.
And whether this would be perceived as a change in use from what people intended at the time they voted with. There's the issue of language and what language would allow, but then there's a question of what people who voted on it at the time believed was happening and whether what's now being proposed would be considered a change in use.
That's right. And, this is something that, although Article 97 has been around for a while, there's not really a lot of guidance out there as to, what constitutes a rescission of your interest, what constitutes a change in use. And as you've seen, you're seeing opinions on both sides of that question. And so, we're giving our best reasoned approach to it. But as you can see, there are other reasoned approaches to it as well. And, so really, I guess it's up to you to decide, how do you want to proceed with this? Certainly, you could err on the side of caution and apply Article 97 procedure. That would certainly resolve any dispute. Or you can proceed under the assumption that this is not a rescission or a change in use, and move forward in that respect.
And because there's reasonable opinions on both sides, it'd be reasonable to expect that there would be a challenge from the people.
Whichever side.
From either side, from either side.
Yeah, there could be a challenge. And, you know, my recommendation would be that, you know, you would likely want to defer to the landowner to defend those challenges, since they're the ones that are interested in having this change made.
Right. Yeah.
May I respond?
Yeah, go ahead.
Yes. It is correct that there aren't a lot of cases on these points, but there has been a case, 2013, a fairly recent case, the Mahajan case. And the Mahajan case said that the grant has addressed the question, what triggers Article 97 requirements? And it said that interests less than an easement do not trigger an Article 97 disposition. For the examples that they gave were licenses do not trigger an Article 97 disposition. And in that case, it was a Chapter 91 license, which you may be familiar with. Is a very, very substantial license. Does not trigger Article 91. So, so the Supreme Judicial Court, in probably the most recent case on the application of Article 97 as what triggers it, said that came down on the side that the situation there did not trigger an Article 97 disposition, and they said that transfers of less than a possessory interest do not trigger an Article 97 disposition.
Okay. Does that answer, Tom, what you needed to?
It does. So
Oh, I'm
that-
sorry, did you, I thought you
I
were
wanted
going
to say, one more practical thing is that the Article 97 would put this whole issue down the road at least a year. It would be devastating for Mr. Mahajan. And it's not a desirable or satisfactory outcome, particularly if it's just as an option. If it doesn't apply, then it doesn't apply. It shouldn't apply.
Yeah, but, so just to be clear, this particular article is just asking whether we recommend to amend
Yeah.
the APR, right? So I know it's tangential to this particular article, but that's not what this article is asking. Are there other questions and specifically related to this? Yep.
Amending the use.
Amending the use.
The use.
Yes, yeah. Questions from the audience before we move to viewpoints? Questions specifically?
Bob Krankowitz, Boston Road. I'd like to add the comment from the Secretary of Agriculture. He deemed that the way the APR
Is
was
this
set
a
up
question? Sorry,
originally.
Bob, is this a question? Because I just want to get all the questions out of the way first before we get into commentary. So that's all. I just want to make sure everybody's questions have been answered first.
Okay.
That's what
My
I said.
question would be to the lawyer here, what is his understanding of the Secretary of Agriculture's position on this situation?
We have addressed the Secretary of Agriculture's position extensively in Mr. McGregor's letter of 2017. This is not an APR that is granted to the Secretary of Agriculture. It is not pursuant to any state program. It is a local, it's strictly local, it's in your control, it's granted to you and in your discretion. So that the Department, the Secretary of Agriculture's signature and approval is not necessary to amend an APR. And that, we're not releasing the APR, it's still going to exist. And it's the Secretary of Agriculture's signature is not necessary.
Do you have any thought on that comment?
I do. I agree with the comment that the Secretary of Agriculture does not have jurisdiction to enforce the provisions of the APR or to compel the town to engage in any sort of process with respect to the APR. The APR was not purchased with any state funds, and it specifically vests discretion for enforcement in the Board of Selectmen. That being said, the Secretary does have a policy with respect to APRs and land that is held for Article 97 purposes. And as part of that policy, the Secretary of Agriculture has determined that for municipally owned Article 97 land, if Article 97 applies and you do not comply, the Secretary may decide to withhold future grant funds for other types of projects. And so while the Secretary cannot directly, in my opinion, have any role in this matter, it could perhaps indirectly have some influence here by threatening to, withhold future grant funding.
Okay. Other questions?
Yeah, I would question, how do you think that the Secretary of Agriculture felt that it had the power, since it followed the basic rules, even though it was not state-owned development rights? Why do you think the Secretary of Agriculture signed off on it, number one? And if he signed off on it, why does he not have the power based on his signing off on the APR and recognizing it as a bona fide APR, as if it were a state operated thing? Could you answer that for me, please?
Yeah, go ahead. Yeah,
Thank you.
You don't have to be there for a while.
Okay.
I trust you.
So the law allows the Secretary to approve of an APR, and that gives the APR a certain status in that it is can remain in effect for a perpetual amount of time, as opposed to other types of restrictions that expire after a certain period of time. So that's part of the statutory mechanism, that if the Secretary signs the APR, it gains additional protections. There's nothing in the statute, however, in my opinion, that gives the Secretary any authority to override the will of the Board of Selectmen as to what the terms of that APR should be.
Okay.
I
Other
might
questions?
just to add to that the APR is valid, doesn't need the signature of the Secretary in order to be valid.
Okay, thank you. Other questions?
Just to confirm, please, if you would, Mr. Corbo. So you said that regardless of whether it is required, that you're aware that the state has stated that we, as a town, would be at risk of losing funding in other areas. Is that correct?
Go ahead.
Yes, that is correct.
In other areas or specifically related
Also,
to?
what the policy specifically says, and this is in the packet. Not exactly sure. I don't know if it's got its own.
Is it one of your opinions, or?
I think it might be within the packet of my opinions.
So we have that
Yeah.
all together.
Okay.
Yeah, I just want to make sure we're clear. Is it general holding of other, like all kinds of state funds, or is it specific to agricultural related future projects?
Yes, I think we can pull up the exact language, but in short, it would be grant funds administered by the Executive Office of Environmental Affairs. So Eric, if you could scroll to.
So for example, if I just, so we're going to have the whole issue of the stormwater management.
Yeah.
To the extent that there were a grant,
Page 3 of 3, you had it up there. Yeah, page 3 of 3 of that document. No, go back.
getting dizzy watching it. So the stormwater management, which I presume is under the Department of Environmental Affairs, to the extent that there were grants related to stormwater management and the state, that department decided to hold back grant funds in the future, I presume that would be that could be a part of what would be held back?
That's correct. I mean, I'm not aware of any circumstances in which that has actually happened, but
Right.
that's what the policy says. So if you look at the very last paragraph there, it says, after the effective date of this policy, Any municipality that proposes, advocates, supports, or contemplates a disposition of Article 97 land without also following the terms of this policy, regardless of whether or not state funds were used in the acquisition of the Article 97 land, shall not be eligible for grants offered by EOEA or its agencies until the municipality has complied with this policy.
Okay.
I'd like to, may I respond to that?
Yep.
Sure. If you look to the first page of that document, and to the last sentence of that paragraph, it excludes from Article 97 land dispositions. It says a revocable permit or license is not considered a disposition as long as no interest in real property is transferred to the permittee or licensee, and no change in control or use that is in conflict with the controlling agency's mission as determined by the controlling agency occurs thereby. So what that is telling you is that if this is consistent with your mission in these APRs, the overall APRs, then you don't have an Article 97 disposition. And of course, that's been our overall theme, that it is consistent with your mission, namely promotion of agricultural use.
Greg?
Yeah, so that circles us all the way back. In order for that last paragraph to apply, the secretary has to find that it's a disposition. Differing people have differing opinions. I have a different opinion, but, the secretary's opinion is going to bear weight in that respect.
Right. Okay, other questions?
I'm sorry,
Not comments,
one-
questions,
Yes, one more. Do you have the letter from the state that indicated that they do consider this a change in use, number one? And also, if you could confirm for me, Jody, the Energy Committee, the Green Communities funding and grants that we've received over the past several years come from this group, and that we've received well over $1 million from them since 2015.
Was it the Department of Energy Resources?
Yes. Department of Energy Resources, and we received, how much?
In the area of 850,000?
Yeah.
Thank you.
So, other questions?
My name is Rob O'Connell from 81 Hildreth, and I just want to ask the board have any of you spent, we all agree this is a state-run program, correct? APR, do we agree with that?
No.
Really?
Yeah.
Well, anyway,
So,
I spent a lot of...
Specific question.
My specific question is, has anyone spent, besides legal opinions, have any of the board set up a meeting with a member of the state APR program and sat down and discussed this?
I certainly have not.
Would you consider that in doing that to get because, with all due respect, it seems legal opinions can sway where they need to go. And I did a lot of research this weekend reading the state APR program and their process of releasing an APR. And I know there's controversy about that, but to me, building a lodge, restaurant is I know, it is a release.
I'm hoping a question is coming at the end of this.
It's coming. So that's my request. Could you, because that information, we've been doing this a long time, but I feel like the state agriculture weighing in, would you take that request?
So, my response would be, it depends on what the town meeting vote says. So if the town, because this petition at this point is just authorizing us to amend, right? Doesn't require us to amend, doesn't require us to do anything. So if for me, if the town wanted us to continue to pursue this, then that is something that I think that I would personally be interested in doing, because I'm certainly no expert. To the extent that the town said that they don't want to do that, then I certainly would not. As much as I love talking to the state politicians.
Haven't we already done that twice, though? Isn't, to me, all right, question. This is like
So I just want to make sure that we keep the emotions down and we just focus on questions.
I know, we're all tired, for sure. My question was going to be that, you have been in discussions initially. I feel you have satisfied them for what you, in the initial part. You brought it before the ATM twice, we voted no. Isn't this, in some respects, a circumvent of the will of the town's vote?
Yes,
where
I don't want to, Robin, I don't want to go there. This
it is
is,
asking you to negotiate again?
but yes, but it's a citizen's petition
their right.
to do
I
that. They
understand
have a
that.
right to do
I
that,
understand
and
One more
and the.
question?
Okay.
Okay, is this a true statement?
What is this, what's that game show?
You're looking for a new lawyer?
Is the only way a citizen's petition not be put on the warrant if what the petitioner is asking is illegal?
No,
That's not true.
That's not true.
So,
I'm calling a hot, what is it called? I'm
Call a friend.
I'm calling a friend, phoning a friend.
Do you have any?
No, so under Chapter 39 of the general laws, upon receipt of a petition, as long as the correct number of signatures are certified, the petition has to appear on the warrant exactly in the form it was submitted. Whether or not it proposes something that can lawfully be done by town meeting is initially a call by the moderator, and ultimately, a determination by the courts if town meeting action is legal. But there's nothing that the Board of Selectmen can do. Once they receive a properly certified petition, it has to go on the warrant.
okay, so I think I heard you say the moderator, no. Does the moderator have any control of that, or no?
The moderator could rule
Okay.
a motion out of order.
Okay.
Yes.
All right, one last question.
That's what you said last time.
Okay, and I'll.
Is it a game show one, or is it
This one to
a?
ponder, but is there any, with all people involved, for me, pause at the financial aspects of this deal on the taxpayers? That's my point. To me, even
That's
if
not
you-
a question, that's a
Okay,
point.
is there any concern about the financial aspects? Because I don't think we're being made whole. If-
There may be concerns, and that will be open for debate when we get
Can I
into
ask you to
comments.
look into that for me?
Yes.
Okay, thank you very much.
Okay. Is it a question?
I have a question. You mentioned release. I mean, everybody says release. It's not a release, it's a change of use.
Right, right. Questions?
Ron John, 187 Concord Road. I'd like just to address this question to the owner of the property, and, because I'm not clear on how this all happened. We have an APR, and APR says it has to be farmed, and then you come along and you buy the property. When you bought the property, were you intending to farm all 9 acres?
No.
So your intention was not to farm?
I had prior to buying it, I had some meetings and et cetera, and before I bought it, I was talking to some people, and they mentioned that they will help me along to go ahead and revitalize it. 6 acres, and the 3 acres, it can be a change of use on it, whatever I need to do, and they'll help me along, and that's why I've been here for 3 years.
So you always felt that those 3 acres were not developable, farmable, and so therefore they should be used, some other use, is that correct?
No, not necessarily, because 6 acres of I'm gonna farm.
No,
I'm
no,
gonna-
the three acres that you.
The 3 acres is not really farmable. I mean, everybody's gone, they've
Well,
taken
it hasn't
soil
farmable.
test.
Well,
Each right?
Question.
The question is,
Please.
the question is, you determined they were not farmable, or they were always not farmable when you bought them?
They were never farmed.
Okay, so they were, so therefore.
Was
then
never
they-
farmed.
That was, you asked the question, that was his, that's why he bought it.
Right. They were never farmed. Right.
So,
Yeah, Greg?
Mr. Chair, can I just provide some clarification as to how we got here in the first place? So when land that is subject to an APR is going to be sold by the property owner, the town has a right of first refusal. So prior to the current owner purchasing the property, he approached the town, and there was an agreement between the current owner and the Board of Selectmen that the Board of Selectmen would not exercise its right of first refusal, and would put an article on the town meeting warrant to ask the voters if they supported a change to APR 3. And based on that, they went ahead with the purchase, and in that agreement, it was expressly stated that if town meeting did not approve of the amendment, then the property would be subject to all three APRs as originally drafted. So the property owner, was aware when he purchased the property that, it was subject to the will of town meeting and that there was risk, and that if the plan did not go through, then the APRs were binding on him.
Right, that's right. Questions?
Yes, I know that the statement has been made before, so I'm curious if Mr. Masaladan would be willing to state specifically who he believes led him to any other understanding, because that innuendo has been flying around for 3 years. And I'm interested to see that there's confirmation either from the Board of Selectmen members who you say committed to that or not.
I hold the fifth to that.
Okay, there's your answer. Other,
What was the answer? I'm sorry.
T took the fifth. It's like sitting up in federal government. Other questions?
I have another question.
Okay.
Bob Krankwitz, Boston Road. What I'm curious about is, let's say the restaurant is built, and in previous go-around, what would happen is the land was sold even after the restaurant was built. It was going to be sold, and the town would have right of first refusal, and it would be sold at agricultural value, regardless of a restaurant being on there. Is that in the language today, in this?
Well, so there's no language today. All this is doing, correct me if I'm wrong, is asking the town whether they are want to authorize us to amend the APR and begin those discussions. So there's no language at all at this point in time, as far as I know.
So if the town votes to have the restaurant,
Well, it's not voting to have a restaurant. He's just, the
What are they
language is
voting?
authorizing us to amend the APR. Oh, I guess it is, I'm sorry.
it looks
allow
like
the
to
guests, I'm
allow a
sorry. Yeah,
restaurant.
you're right, you're
Yeah,
right.
it looks like that means it's a go-ahead for the town to have the restaurant.
Right, but then
And so then
there's
we
a whole
start
set of
working on-
negotiations. Yep.
But if I can just, as Mr. Corbo pointed out, when Mr. Ebby entered into an agreement back in 2006 in which the town waived...
2016.
2016, in which the town waived its right of first purchase.
First refusal.
Yeah.
Well, this would have to happen again if it went up for sale, because that's part of the APR requirement. Yes? No? Or
As,
the deed requirements?
As Mark said, it's a negotiation after the town meeting.
Right, so, again, all this is doing is authorizing us to amend it, and then there'd be all kinds of, public processes and open hearings about what those would look like, and
Ebby just mentioned it would be a
it
negotiation.
doesn't force us. All it's doing is authorizing us. Doesn't mean that that's what we would want to do at that particular
But
point.
Ebby just said that a negotiation, that would be a negotiation with who? The citizens or the Board of Selectmen?
That's Board of Selectmen.
Okay, thank you.
Other questions? Questions?
Just a very quick point. Just a
Got a
very quick
question?
point. I'll put it in the form of a question.
Please.
We are
Okay.
planning
If you speak to the state on APR, is it true or false? On APR law, they will tell you that that nothing can be accepted into the APR programming unless it was farmed 2 consecutive years prior to it being applied for an APR. And if we call the state, they will tell you that. So it's just a point of clarification.
They
and a
will
question.
tell me that, or are you
They-
asking
no,
if they
will
would tell me?
They will
Okay,
tell you that.
so it's not a question.
All right, well, I snuck it in.
All right, questions, please.
Hi, I'm wondering if there is commercial, I'm
us who you are,
Beth
Beth.
Morrison from 10 Kelly Road, Westford. I'm wondering if there's commercial space available in town for a restaurant currently.
I would say yes.
Yes.
Has the Economic Development Committee consulted with the developer about current space that is available, that he could currently
Aren't those the
lease
petitions?
right now and do a farm-to-table restaurant? He could be farming the land right now and have a restaurant going right now
So,
in commercial
questions,
space.
So, please. And now we're starting to skirt the opinion versus the questions, but the two petitioners, as individual citizens, are on the Economic Development Committee. Okay, questions?
Emily Teller, 9 Texas Road. I would like to read part of the original agreement and ask you all about it. The question coming. This is number
How long?
9. This is number 9 on the original agreement signed by the Board of Selectmen and Ebby on January 12, 2016. through its Board of Selectmen. If town meeting does not approve the amendment to APR 3, or if the buyer fails to secure all licenses, permits, and approvals needed to complete the project, or if the buyer abandons the project, or if the project is not completed for any reason, the buyer acknowledges and agrees that it will own the property subject to the existing APRs and that it will use diligent efforts to comply with the terms of the APRs by developing active agricultural uses on the property. So my first question is to Ebby, your attorney, or do I need to ask through you?
You don't have to be
Okay.
formal, just ask a question.
You also, at the beginning of this meeting, stated that the land has been not farmed for 10 years, and I believe that Ebby has owned that land for more than 3 years.
3 years, yeah.
And you have not done anything actively agricultural on that land for a third of that time that you basically said was pejorative to the
There's
land.
absolutely no soil on that land. I brought in over 4,000 yards of soil. It's cost me somewhere around $65,000, $70,000 to bring in soil. And last year, I planted rye over there. And this year, I had to bring another 2,000 yards of soil to that property. It had to be tested, make sure it's not asbestos or anything on it. And unfortunately, because of the rainy season that we had, I couldn't get the loam to APR 1. APR 2, I filled it with the soil, and I put the rye on there. We harvested it, and that's all I could do. And that's why I transferred all the 2,000 yards of soil to APR 1, which it hasn't had soil in God knows how long. And hopefully, I'll get that one by springtime, spread, lined, and reseeded for some more rye.
I guess I would appreciate
Question?
if you would please not saying it was 10 years fallow. My question is, the people
15
who
years
have
fallow.
signed this, the people who signed this agreement, according to my trying to figure out legibly, include Kelly Ross, who's obviously not on the board, Andrea Perner-Sweet, somebody who did a CY, it looked like.
CY?
Isn't that your signature?
It very well could be, because
Okay.
no one
Doesn't
can
look
read my
like an
signature.
MK, but it looks like a CY. And then Scott and Don Siriani. So my question is, for those of you who signed this document who are still here, how do you feel about, what's your sense about the town meeting saying no to the APR? Is that okay with you? Is that what you would want?
Well, so you're asking for individual, we're not talking about opinions. So I know it's a question, but we haven't gotten into our opinions yet about the particular article, so I would like us to hold off.
I would appreciate, would you please consider that?
Well,
Is
yes,
that for my
yes, we will.
question? Is that good?
Yes,
Okay.
and we will, I mean, when we take our vote, you're gonna know what our opinion is.
Okay, I'm also, I do have to say something while I'm here. I'm really not comfortable in some ways with you putting off something till the motions meeting tomorrow, Mark, because that's not a public meeting. You said
But
earlier
it's a
tonight.
legal question about whether it's 2/3 vote or a majority. It's a legal
Could our
question.
attorney answer that now for the public?
Yeah, go ahead.
Answer what, that it's a legal question?
It's 2/3 majority.
Well, that's the whole dispute. In my opinion, is that it does not need a 2/3 majority, because this is not a disposition of the town's interest in the land, and does not trigger the requirements of
Right,
Article
and since,
97.
and because it's a legal opinion, and unless there's other attorneys here, that's why I would prefer to do that. That's not on the agenda for tonight. I would prefer to do that in the motions meeting when we have the ability to have a legal discussion in a roundtable.
Will there be more than this gentleman there tomorrow?
He's our attorney, so.
I know. Okay.
So,
All right, so
no.
that's, okay. Well,
Okay, a question, please.
it seems, hold on. Why is the interest of the town not being considered changing what is on one of the APRs?
So as I've explained in my correspondence, Article 97 and Chapter 184 talk about the town having, when it acquires an APR, an interest in the land. And it talks about a procedure for the town to relinquish its interest in the land. In my opinion, what's being done here, if it goes through, the town retains its interest in the land. It still has the APR, it still has the right of first refusal, it still has the ability to enforce the terms of the APR, it still has the ability to limit what's done and to require that the property as a whole be used for agricultural use. So based on those factors, it's my opinion that this is not a relinquishment of the town's interest in the land. And as has been pointed out, some of the courts that have looked at this have said that there's a difference between doing something that is a permanent disposition of an interest, like an easement or a sale, versus something that is more temporary in nature, like a license or an agreement or a permit. And in my opinion, what's being done here is more akin to a license or a permit than it is to a disposition of the town's interest.
There's going to be a building on that land.
Okay, so that was
That's
answered
my
your
last
question.
statement.
Okay. Other questions?
I'm Robin Connell from 81 Hildreth Street. If I could wiggle my nose like Bewitched to make this all go away, would you want me to do it?
Please, questions.
Okay, my question is, in 1997, it's going to be a question. In 1997, when at an ATM meeting, it was a 2/3 majority vote that had to vote to buy these 3 APRs from the current landowner at $525K. So my question is, if we had to have a 2/3 majority vote to buy them, and I assume the answer is going to be money, why don't we need a 2/3 majority vote for, again, it's money, and again, my concern is we are not being financially made whole.
Okay, the question
with our
is,
investment.
yeah, thank you. Go ahead.
So there is a procedure for an acquisition of an interest in land, and when the town appropriates money to acquire an interest in land, it requires a 2/3 vote. The 2/3 vote that was taken authorized the Board of Selectmen to acquire the APRs on such terms and conditions as the Board of Selectmen deemed in the best interests of the town. So town meeting did not specifically set the terms of these APRs. The Board of Selectmen at the time did. And again, the reason why a 2/3 vote is not required now, because in my opinion, the town is not relinquishing its interest in the land. The town is retaining its interest in the land. It's simply changing the terms as to what can and cannot be done on that land.
How could we ever go back to our APR as it is if this structure is built on that land? How does that happen? That's beyond me, how we could go back to the original intent of the APR with a 15,000 square foot building on it, impervious parking lot. How does that happen? How do we go back and say we haven't released the APR? That defies logic to me.
I don't know that that's really a question. I
So-
mean, I can't answer how you would remove a building, and buildings get removed all the time.
Actually, I had written down a very similar question, Robin, and that had, I'm saying you're trying to understand how a license or permit equates to a commercial building with an acre or more of parking, when the resource we're talking about is agricultural land. And yes, it's been stripped of topsoil and can't be farmed in that way, but it could be used for other agricultural purposes, greenhouse growing, potted landscape plants. There are other agricultural functions that could happen the way the property is now. And I can't get my head around equating a license or permit, which in my mind is a piece of paper that allows you to do something, have some type of activity there, but not change the entire makeup of the property when the whole point is that it's agriculture production.
Well, so there's 2 things there. First of all, if it's your judgment as a board that this property is more suitable for agricultural use, that's a policy decision that you would retain after the town meeting vote. And as Mark pointed out earlier, the town meeting vote is going to authorize you to enter into negotiations to provide this amendment. It's not going to require you to do that. So to the first point, it's up to you to decide, whether or not this has value. And, the reason that's been put forward is that the reason that this has value is that by putting the restaurant on 1/3 of the property, it enables the other 2/3 of the property to be restored to active agricultural use. Whether or not that's a viable answer, again, is your decision to make. But on the law, there's a difference between a permit or a license and a disposition or an interest in land. And it doesn't have to do with the activity or the construction. It has to do with the nature of the approval, okay? A license or a permit can always be revoked, okay? A sale or an easement cannot. And so here too, you know, you're talking about an amendment of the APR, and you still retain your enforcement authority if the terms of the APR are not being complied with. You retain your ability to exercise your right of first refusal if the property is going to be sold to a third party. And you retain the right to control, you know, to an extent, what's happening there. And so it's because you're retaining your rights or your interest in the land is that I say that you're not relinquishing that right. And yes, I would agree that, you know, the building of a restaurant seems like something that is permanent, but I mean, it's not necessarily. You know, a building can be taken down. And again, you know, that part of it though is up to you to decide what's in the best interest of the town going forward.
Okay.
One last, I promise. Can I ask, Evie, can I ask you something?
Yes, ma'am.
Can I just ask you if when you ventured into this real estate looking for this kind of thing for your project, did you investigate buying any commercially zoned land for it?
I did not. I fell in love with the land, and I thought I could do something really good with that
Okay.
property.
Would you agree that commercially zoned land would be more expensive?
No, absolutely. The land was up for sale for a year. How come nobody went and bought it? They
All right, so I don't want to, it's not relevant to this particular. Okay, other questions pertinent to this article, please?
Bob Crankwitz, Boston Road. Elizabeth mentioned something, Robin did too. In the APR, all the APRs have an intent and a purpose, and one of it is that...
Is this a question, Bob?
Yes, there is. I'd like Mr. Corbo, is that correct? Mr. Corbo, to explain to me how in that introduction it says that non-agricultural use will not be accepted to be done on that APR, and this is specifically APR 3. How does that fit with your whole explanation in general? In other words, a restaurant is not an agricultural use. How does that derogate or change the meaning of the intent of the APR? Could you explain that, please?
Yes, so the way in which the project was explained to me is that the purpose of the restaurant is to foster and increase and improve the agricultural use of the property as a whole. And you've got to remember that although there are 3 APRs, this is one parcel of land. And the reason that there are 3 APRs, although I wasn't here, but I believe that the intent was to spread the cost out to the town over 3 years rather than having to pay that cost all at once. But so this is one property, and the intent of the APRs as a whole is to have this property be put into agricultural use. And the way that it's been explained to me is that this particular restaurant is going to use product grown on the property in a so-called farm-to-table way, and that by having the restaurant there, it's going to foster the ability to use the remaining 2/3 of the property for agricultural use. Again, whether you find that that is a viable or a feasible explanation, that's up for you to decide.
Okay, thank you. Hold on, I'm taking questions. I just want to make sure I'm watching you guys as well as, okay, questions?
Yes, I have to wonder, and I'd be glad to, I'm offering, if you'd like, for me to forward to you, there was a letter from the EOEA that stated that the placement of a building and parking lot at the size and structure that is being proposed is tantamount to a release, and that would trigger Article 97. That was one statement. I'd be glad to forward to you if you'd like that letter. And second, I'm curious as to how much we've spent in legal fees on debating this in the past 3.5 years. Do we know?
I can't answer that right off the
I'd be,
top of my
I'd be
head.
interested as a taxpayer of this community, how much we've been spending on legal fees.
I'm happy to research that, but
I appreciate that. Thank you.
Other questions specific to the article?
It is.
Okay.
Okay. Write it down.
And I read.
Okay, if 16 passes, personally I hope it doesn't, but if it does this mean that BOS will permanently have voting control over this property in perpetuity versus the taxpayers? And will our voting rights ever be restored over this APR? This is what they're asking us to give up. And does it also include the other two APRs? I stumped you.
Well, because it's not.
I doubt it.
It's not entirely clear to me what voting rights the voters have.
I was going to say, because they rest with the
over
selectmen.
this. The APR makes very clear that the terms of the APR were subject to the discretion of the Board of Selectmen. And, you know, the only way in which the voters would have an interest, again, is if the Board of Selectmen were to decide to dispose of or rescind its interest in the APR. Otherwise, there's no change in the way that this APR is administered, and whether and to what extent the board enforces the terms of it is really in the sole discretion of the board, and the town meeting has no say over that. And in fact, we have, prior to this ownership, gone to court to enforce the terms of this particular APR.
And so that is, for me, the reason why I want to hear from the town. I'm not interested personally in doing something that the town is not interested in having us do.
Right, because we've been voting on it all along.
I understand. Okay, so this particular citizen's petition, right? We didn't have a question. This isn't something that we chose to put on,
Right.
This was, the citizens came forward and asked us to be on the town meeting. So for me, I'm wanting to hear, all right, so maybe once and for all, you know, relative to the citizen's petition, is the town interested in us possibly amending the APR? And if it is, okay, well then we have a whole bunch of other stuff that'll be very fun to go through. And if they're not, then I think, you know, okay,
Then we
then
move on. But I just implore you to get a hold of the state.
your question, it's a question, yes?
I know, but I'm imploring.
Okay.
Emily Teller, I need to read something again to clarify something that you said, and then I have.
In the form of a question.
Yes. You talked about the acquiring interests and how the amendment wouldn't change the interests. So of the May 1997 town meeting to change the funding for this land, Article 12 said it was voted 314 yes and 60 no that the town amend the vote adopted unanimously under Article 23 at the special town meeting held on October 21st, 1996, so as to authorize the treasurer with the approval of the Board of Selectmen to borrow the sum of $525,000 under the and pursuant to Chapter 44, Section 7, parentheses 3 of the general laws or any other enabling authority in order to raise the appropriation of $525,000 made by the vote for acquiring certain interests in the real property located at Boston Road, known as Drew Farms. So that superseded the 3-year plan. And I talked to Dan today, our treasurer, financial director, and he confirmed that $175,000 was bonded in December of 1998. Where the other money came from, he could not pull it forward. My question is, Mark, specifically for you, I feel like you're bullying the public by limiting things to the question. I just want to know, are you going to allow another 45 minutes for comments? Because, you know, you're really narrowing this.
I'm not sure why a personal attack when all I've...
Because you're chairing the meeting.
You're doing a great job.
You're doing a great job.
So all I said right at the beginning was, I'd like to get questions taken care of first before we get into commentary to control the emotions. So I could care less. If you want to stay till midnight and have a tete-a-tete, let's do it, okay? I don't really care. The purpose, as I said right from the beginning, and maybe you didn't hear me, was I wanted questions first so that everybody was on a level playing field before the emotions of what I know is coming happens. All right, so if you have a problem with me, let's talk about it afterwards, but right now, it's focused on questions.
Please don't limit the comments at a point when
What
they
gives you the
start.
opinion that I'm going to limit the comments?
I've been here before with you chairing a meeting, so thank you.
For Christ's sake. Anybody else have questions?
Yeah, I have a question. Bill Taffel on Cold Spring Road. There's a lot of debate about whether this change would be a release or not. My understanding is that if it is determined to be a release, which would probably be something that happened in the court of law rather than us debating it, that then Mass General Law 184 kicks in that requires 2/3 vote of both houses of the state legislature? Is that correct?
Yes, that's correct. So, the determination that this is a disposition in the land, of the land, if that were to happen, doesn't mean that this amendment can't take place. It just means that there's a different procedure, okay? And so what that procedure requires is several steps. First of all, it would require a 2/3 town meeting vote to authorize the disposition of the town's interests. The Secretary of Environmental Affairs would require that you designate, I don't know what the word is, like alternative or compensating land, I'm sorry?
Land exchange?
Yeah, so that for whatever land you're taking out of an APR purpose, you designate some other land to put into it. And sometimes they require that to be at a 2-to-1 ratio. So that then would likely require a town meeting vote. And then ultimately, the decision has to be approved by special legislation at the state legislature, approved by 2/3 vote in both houses, and then ultimately signed by the governor. So, yeah, there are many more hoops that you would have to jump through from a procedural perspective, but it's not to necessarily say that it couldn't ever happen.
Questions?
So just follow-up question. So my understanding though is that the 2/3 vote of both houses of the legislature is entirely dependent on whether it's determined to be a release or not.
Well, that's correct. If it's not a release or a disposition, then the state legislature never gets involved.
All right, so it sort of boils down to that one word.
Correct.
Other questions?
Craig, it's Boston Road. Are you aware of Secretary Beaton's letter, February 2017, directed to Andrea Paranis Sweet with regard to this property?
Yes, I'm aware.
And basically, are you aware that the Secretary of Agriculture's comment was regarded by that office as bona fide, which we've already discussed before? And are you also aware of the opinion of the memorandum of the Massachusetts Land Trust Coalition, the bevy of lawyers who are very well educated in environmental law? Are you aware of that amendment? Memorandum, I'm sorry.
I'm aware of those opinions, and as I stated at the beginning, there are opinions on both sides of this debate by many well-educated lawyers, including myself.
So does that mean we'll probably go to court to adjudicate this?
Beth Morrison, 10 Kelly Road. Could I request that we have some state officials at town meeting to educate us on what the state's position is, because there seems to be a discrepancy between the legal opinions that we've heard here and that I read in your packet and what the state is saying. So is there a process to ask the state to come to town meeting to discuss the various agencies and their opinions? Because I would like to hear that.
Any specific ones?
The ones you mentioned?
Oh, yes. The Executive Office of EEOA, Environmental and Energy.
So why don't we talk about that at the motions meeting tomorrow? Not aware.
And the Secretary of Agriculture. The vote.
So we'll talk about that tomorrow.
Okay.
Other questions?
Just a side point.
Question?
Is
that a question?
Motions?
Question?
Microphone.
Okay. Craigwitz again, Boston Road. Is the motions meeting open to the public, or is that closed?
Nope.
Closed? Okay, thank you.
Okay, so I just want to be very clear. I'm not going to limit time for comment. Yes.
I I actually don't think you can keep it public out of the motions.
Oh, okay.
So
No, I didn't
just
know.
want to mention that.
Okay.
It's not an executive session. so-
Okay, that's fine.
It's not a posted meeting, it's a group of us talking about the document, but you can't.
Then it's open to the public.
Yeah.
Is
That's
it
a
a
s-
board? It's not a
small
board,
group.
it's not a, there won't be a quorum of a board there, right?
Oh.
So then, no, it's not open to the public.
Okay, done, overruled, so,
Say that again, I'm
thank
sorry, I
you.
didn't get it.
If there's no quorum of a board there, it does not have to be open to the public.
Okay, I wasn't aware of that.
So, okay, is everybody clear? I'm not limiting time. Okay, everybody good?
I'm not
So
clear on
if-
that
hold
point,
on,
though.
hold on. If you want to be here till midnight, fine with me. But I would ask one thing. Let's not be repetitive, okay? If you've got something to add to the commentary that will aid in our decision about, or recommendation, or whatever we're going to do tonight, otherwise, let's try. And I do have some discretion in my highly paid role as chairman to do that, but I will try not to do that. Yes, Bill?
I just want to hear the resolution of the two opposites. I heard about tomorrow's meeting. Can I go to that or can not? I want to know which way it is.
So, I will say that the meeting is not required to be open to the public. I will defer to
Thanks a lot.
Jody as to
Thank you very
whether
much.
or not that is.
Listen, I don't care. Because there's certainly not any hiding going on, but, that meeting starts at 2:30. I can't stay past 4:30, so, I'm gonna be more judicious about, because we have to get through the things we have to get through at that meeting, so.
And that meeting is
I may
not-
not be as nice as I'm trying to be this evening.
Thank you. And sorry to interrupt, Mr. Chair, but that meeting is not a meeting at which things are substantively debated. And it's a meeting in which we walk through the town meeting warrant, we talk about who's gonna address which articles, who's gonna speak, what the presentations are gonna be like. It's not an opportunity for debate on any of
No.
the substantive issues on the warrant.
Tom?
Just,
It's pretty dull.
Yeah, it is.
I guess maybe just for me, but maybe for the benefit of the public. So the Article 97 question. This is deciding whether the town supports an opening of a dialogue. There would be a subsequent decision about whether we had to go through the Article 97 path.
Well, there'd actually, before that, then we'd have to make a decision about whether we want to follow through on town meeting, right, which I assume we would, but yes, so that would all be part of.
Okay, so the whole decision about which path we would go down would be a deliberate decision that we'd make with information, and it would happen
In public.
later, and that's not what we're trying to do at this town meeting. We're trying to do in the town meeting is only get almost a straw poll indication from
Well,
the
the
public.
citizens, that's the citizens are asking.
That's what the citizens are asking for,
Yeah,
it's not we, okay. Thanks.
Again, Bob Cranko, just a quick question. Are you going to vote tonight on the, whether,
Maybe, depends on what
or
time
are
it
you going
is.
to wait till just before town meeting? That's what
Maybe,
it says in the warrant, that you'll wait just before town meeting.
no,
You will decide tonight?
maybe. It's up to the will of my peers. Bill?
My name is Bill Harmon, and I have a question. Your attorney Corbo said this a few minutes ago. That's up to you to decide. And my question now is, will you be deciding that here tonight while I'm here, or will I have to come at an inconvenient time tomorrow to hear that decision?
Decision of what?
Oh, of whether to use the Article 97 process.
Oh, we're not talking about it tonight or tomorrow.
That's not what that's.
He didn't say that.
So then
Did
when
say
will
it
that
would
be
be discussed
decided?
in the motions meeting, that the majority or
The majority
two-thirds
versus
vote,
the
you said it
two-thirds would be set, somebody
that-
said that would be
yes.
discussed in the motion session tomorrow.
Oh, but Tom Clay was saying there's no substantive topic tomorrow. But that, to me, that's the most substantive of any topic to me. So I would prefer that you decided that tonight.
Yeah, my understanding, but maybe I misunderstood, was that this would probably stand as it is, but the whole issue about whether we go down the Article 97 path or not is not this.
No, that's not this. So if I said that, or thought something.
So the logical thought of that would be that this would continue to
Yeah.
be a majority vote, because all it's doing is giving some direction or indication. There would be a subsequent decision about whether we pursued an
Yeah,
Article
when
97.
we were talking about majority versus two-thirds, it was related to what's required in order to do this particular citizen's petition.
Right, okay.
Not related to Article 97.
Well, these words that's up to you to decide. I think it's pretty clear to me, and I'm anxious to hear you decide that.
Hear me decide what?
The thing that Attorney Corbo was talking about, which is, well, he was saying that there's a distinction between a license, which can always be revoked, and
That's not the
something that's
citizen's
permanent,
petition, though. The
and
citizen's
something that cannot be revoked.
The citizen's petition is only authorizing us to amend. And that's the only article that's going to be on the town. So I don't have any intention of talking about what happens post this article personally tonight. We're not being asked to.
Oh, that's later.
Pardon?
That's after town meeting?
Yes.
What you're saying? Oh, all right. That
Yeah,
answers my question. Thank you.
As far as, yes.
Can I make a point of clarification? So the finance book that was mailed to you, in the finance book, it does say selectmen recommendation at town meeting on this, but that's because they hadn't taken a vote before this went out. So they may vote tonight, but they will then tell town meeting what their vote was, so that's what that means.
I wasn't inquiring about that angle.
I know you
I'm
weren't,
interested in that too,
but that was the prior
Article 97
question.
seems so obvious to me, I would just hope that selectmen would get to that.
I don't have any intention of talking personally.
That's after town meeting. Okay, thank you, Mark.
Because there's nothing to, if the town doesn't want us, doesn't authorize us to amend it, there's no Article 97 to talk about.
The final paragraph of this article motion reads, "And further to authorize the Board of Selectmen to take all actions, enter into all agreements, and execute on behalf of the town any and all documents as may be necessary or convenient to effectuate the purposes of this article or act in relation thereto." So this is basically saying, go for it, and that we won't have to necessarily vote on this again, which is why we're having the conversation about Article 97. The way that this is written, it's giving you that authority.
Oh, is that legally, is that, because I know it does, I'm not sure that's my intention, but go ahead.
Yes, I mean, it gives you the authority to do what's here, which is to amend the APR. It does not give you the authority to do anything else.
Right. Right. Okay, so now, let me start with the board. Need a break. So, thoughts or comments related to this article before we ask the audience?
I guess, could I take advantage of some of the wisdom here, who were part of this before, and it feels to me like...
Careful how you use that word.
I'm not so sure we will.
No, you've corrected me many times before, which I appreciate. I guess for me, this seems like a pretty substantial change to what the voters were thinking about at the time that they voted. And so I know there's sort of a legal determination to make, there's sort of what the language would allow, but in terms of what the voter was thinking at the time, it seems to me that the voters were thinking it was going to continue in sort of the form that it had been. And I think this is a pretty significant change. And so I feel like the time that we would vote, or I would vote to support something, would be if I felt like we've looked at this carefully. The only viable path forward to get any agricultural use on this property is through this kind of compromise. That could be true, but I'm not sure that I'm there yet on it.
So those of us who were on the selectmen at the time, you're asking what we thought?
Well, I know that there was the whole Drew Farms task force, and a lot of work went into this to look at this. Do you feel like there was ever a time when there was some consensus that the options that could be possible on that property had really telescoped down to the marriage of a restaurant in the property? Because I could imagine that being a determination after careful study. I just don't know if anyone ever reached that.
So having chaired that committee, I can say that, and there are other members of that committee in the room, so if you folks disagree with what I'm saying, please feel free to chime in, but I don't think we ever reached that consensus, okay? I think we had a lot of discussion about what a lot of different things could happen on that property. Some of them we determined were not viable, some of them we determined maybe, some of them seemed ideal to us, but we didn't know if we could do it. A restaurant certainly was in the mix as a possibility, and we discussed it, but the committee as a whole never came to a consensus about that. And I don't know if folks disagree with that who were on that committee, but I don't think we ever came to a consensus. So.
That's helpful to me, because this looks like the kind of thing you would say, at the end saying, look, the only way for us to preserve agricultural activity there is to marry it with a commercial enterprise like this. I could imagine that being the outcome, but it doesn't sound like we ever reached that outcome. We never got there.
I don't think we ever did.
No, and on my side, it was always under the understanding that this still had to go through the myriad of town boards and committees and all the other thing, whatever it was that was going to be there. That's why the negotiation ended up like it did. You know, there were the options of a restaurant, but at the time, we didn't know enough to know whether that would ever go through or not. And so it still has to go through all these other things. So if it makes it through all the other things, including whatever public sessions for all the various planning boards and the ZBA and conservation and so on and so forth, then so be it. But that was it.
Thanks.
Scott, anything to add?
I mean, if you're looking for opinions, I mean,
Yeah.
the will of the town is town meeting. Town meeting has said no twice, so I'm not going to say yes tonight.
Hold on. Anybody else just on our?
Well, I think Keith maybe was going to follow up on Tom's question. Was that?
Oh, okay. Go
From
ahead.
the committee.
I'm
Can you introduce yourself, Keith?
Keith Bowman, 31 Tadmuck Road. I guess that we never did come to an opinion of what the end use of that land should be. I think that we started out with a diverse group, many of whom were dead set against anything like the restaurant. At the end of 2 years of conversation back and forth, we had eliminated almost everything that was possible there, except give whoever owns that land the possibility to make that land economically viable. And the only way that we could figure it out, and this conversation was had in more than one meeting, was that you'd have to have something on part of that land that could generate the income so that the rest of it could stay open. I just think that we went through the situation of could the town buy it? And we found out that, well, the first problem was that the evaluation of the land came in at more than the asking price. So that eliminated, I think this is right, it eliminated using CPC funds to possibly buy some open land. Okay, so now we have to bond the land. So we're asking the town to jimmy up $700,000 for this piece of land that we really don't know what they're going to do with. And the second part of that situation is that the Board of Selectmen cannot enforce the APR upon themselves. So in order for the town to buy that land, they would have to get another entity, like the Audubon Society, to enforce the APR. And we didn't come up with any real sound numbers, but numbers were bounced around like $20,000, $30,000 a year for this to happen. And I don't remember everything, but I think that we kind of considered that that was a lot to ask for the town to take this on, again, for a piece of land. What's your plan? And if you buy it, is it going to stay open? Or will there be a fire station there? We didn't know. So in the end, I think that we recommended, at least if we didn't say it in specific terms, the committee felt as though the town really shouldn't buy the land, and we should give another owner an opportunity to do something else with the land.
Thank you.
May I ask Abby to respond to the question, is this the only option? Can you speak to whether or not this is the only option?
I really don't have any other option unless a lot of people tell me I should have a marijuana farm over there, but that's not my cup of tea. So I'd like to have a restaurant. That was my idea from day one. And I'd like to present the town something beautiful, as I've mentioned for the past 3 years. I've been before you so many times. And I'm going to make a go out of it. I'm going to make a nice farm out of it. I'm going to make a nice restaurant that the whole town of Westford would be proud of it. That's my agenda for the land.
Hi, so farm stand would be an option that I'm sure would go over well with the community.
Sorry. I had asked, I didn't see anybody else had anything.
No, Keith jumped in the middle, but
Okay.
I have opinions to
Yes.
share.
Sorry.
before we
No,
open
you
it
go,
up.
Elizabeth.
Do you want to go, Andrea? Did you have anything?
No, you can go for now.
Abby, I have
Can I answer a question, the farm stand?
No, well,
No,
hold on.
Elizabeth-
We'll come back to it, so.
Yeah.
So I have a very sincere question, Ebby, and that is, why are we doing this again when we did it 2 years ago? And what I heard at the previous town meetings about this issue were three things. The first town meeting, it was very clear that the town wanted the right to purchase it back at agricultural rates, should you ever leave the restaurant business and put it for sale. That was a huge issue at the first town meeting. The second one was people asked for a smaller restaurant, and I know it's reduced by a few hundred square feet, but when people said...
It's a third now, from 38,000 to 13,000.
No, I'm saying reduced from the size you proposed 2 years ago. I know the first time you had the function hall,
It's half of it now.
you reduced that, and then from 2 years ago to now, it's not substantially smaller than what we had.
It's half the size. It was
From 2
25
years ago?
It was 38,000, 25,000, now it's 13,686.
Okay. And then the third issue was the town, many folks who voted against it were asking that the town be compensated at commercial property rates, and not just give us interest on the 175,000 over 20 years, but we all know land has gone up, land values have gone up much faster than that. So we know the commercial interest in that property has grown faster than interest rates. So those are the issues that I heard at town meeting, and to me, those haven't been addressed in what you've brought back. So what makes you think the town is going to vote yes this time around? And you can see a lot of people are spending a considerable amount of time on this issue, and I feel like what you're proposing doesn't even get close to what the town had asked for.
Well, I think I've made a huge point on the size of the restaurant. And the second, well, the value of the property was, I believe, 2014 or 2015. Somebody had I don't know if it was a town or somebody else, the value of the land was at that time $725,000. And when I bought it from Tom Goddard for $650,000 at the time, and that was the value of the land that he put on it, and that's why I bought it. I have no idea. People are saying the land is worth $6-7 million or whatever. I've offered to sell it to them for $3 million, $2 million, but nobody wants to buy it. It's just a bunch of people coming up with all these figures and all that because there's a fire station now. And across there, it's going to be a farm and a restaurant. And so much of the land is going to take as an easement for a sidewalk for the town of Westford. And is that going to be going through the town for the Article 97 or et cetera? No, I'm cooperating with the town to give the town what they want and also bring something beautiful for the town that at least people can be proud of it. I mean, I have, as you mentioned, the land is not worth what people are talking about. 5, 6, 7. It's not a commercial land. It's an APR land, and I'm just changing the use on one of the parcels to bring it where it should be. Keith Boney himself for 25 years, Tom Goddard for 15 years. If Juliet says that the town put a farm stand over there, if they would have made money out of the farm stand, they wouldn't go out of business. They wouldn't sell it. So the only viable thing is, I don't want to put a McDonald's or a Burger King over there. I want to put something that people can be proud of it. And there's a fire station across it. People didn't fight that.
I'm not talking about the fire station. So just when we think about 3 acres of land being sold to allow a restaurant to be built, in Westford, if you went over on 110 and purchased 3 acres of commercial land with a building that's ready to be torn down, what you would pay for that land on 110 that already has permission to build a restaurant versus the land in APR 3. That's the difference that we're talking about, and that's what I heard voters asking for, to be compensated for that comparison, that difference. We can figure out what 3 acres of commercial property on 110 cost, and we know what you paid for those 3 acres. So we can get closer to a commercial.
I'm on Boston Road. I'm on a farm. It's a farm that 3 acres, it's not a release, it's a just change of use, and the town is going to have the rights for, God knows, for the next 5,000 years. So I'm not buying the commercial land, I'm not buying land on 110, I'm just buying a piece of property that's a farm, I'm changing the use of it, so the other two APRs can be redeveloped to a farm.
So my point is that these 3 considerations, and actually I recalled, what is the seating in the plan from 2017? And what was it in 2000?
250, I believe it was.
So you reduced
Actually,
it.
it was 384 with the function hall. Came to 250, now it's 194.
So you've reduced the square footage, you're saying, by 50% from 2 years ago?
More than 50,
But
yeah,
you've
by
reduced,
50%.
you've only
Well-
reduced the seating by 20%?
Right.
Okay. All right, I'm just trying to understand because I didn't think there was a big difference between the seating in the previous two proposals. And
Like
I had
56
assumed
seats.
I'd assumed the square footage was, directly proportional to the seating.
Right.
So anyway, my point is that those were the three issues that I heard at the previous two town meetings, and I expected those to be addressed to a greater extent in this proposal. And I don't see where they have been, and I see that, a lot of folks in this room have been asking me why are we doing this again without substantial changes to the proposal?
Well, I think I have made a big difference on the
Anything
size
else,
of the
Elizabeth?
restaurant.
I just had another comment about I know in the beginning you said you would start farming, back in 2016, you said that if it didn't pass, you would start farming, and 3 years later, we're still sitting there with big dirt piles, and I know you explained it was too wet to get all that soil spread last year, but we've had 3 years, and I
Last
expected
year-
it to be.
Well, it took me a year to get all the garbage that we collected for the past 45 years. I took them all out.
Right,
And I
I
brought
just-
loam in, which they have to be certified.
Right, I know we approved
Right.
bringing, and I understand bringing all that loam in, and I know you're investing, but I'm just saying, after 3 years, still looking at those piles of dirt sitting there.
Well, I brought it back in October and November, unfortunately, because we had so much rain, the trucks couldn't go up to APR 1. So that's why I left them over there now. Past couple of weeks, they're all dispersed over to APR 1, which hopefully by April, when the ground is nice and solid, we can go spread all that over there and put lime and get some rye going again.
Okay. You have anything you want to add?
Not right now.
Scott?
No.
Tom, you're good for right now? Good. Okay, so, again, if it's incremental to the conversation and comments that haven't been made before, then
Agreed.
please have that.
Thank you. Question, this is still owned by an LLC, is that correct?
LLC, I have a partner, so it's an LLC.
Okay, and an LLC, if so, can be transferred to another owner without triggering right of first refusal, correct?
Yes, I believe that that's correct, that interests in an LLC are not necessarily considered a disposition that would trigger Article
I
97.
had no intention to put it on LLC because I had a partner, I had to protect him and myself.
Yeah, no, we've had this discussion before, just as a board, and then it would depend upon if there's anything we could put into the language that would allow that. That's all. Yeah.
Thank you.
Bob Krankwitz, Boston Road. To add a fourth one to one of your things, Elizabeth, I think one of the things that the citizens are concerned about is you want to put a commercial venture, which may or may not fly, may fail, many businesses do, the first restaurant, now, let me finish, it's in a residential zone. That's a big thing. It's against our zoning bylaws. It's right there, table of use. You check it out, it's against that. The other question is there anywhere in this petition or where we stand as far as, I brought it up before, but it was as a question. It wasn't as a question. This is kind of a statement. In the previous go-around, the land, if it was to be sold after the restaurant was built, and either because it was a bad deal or whatever, it was sold, the town would still have right of first refusal if it wasn't limited by the LLC requirement or statements.
Yeah.
Does the town then able to buy the land back at agricultural value and forget the value of the restaurant, just the agricultural value of the land? So that needs to be addressed.
Yes, that would, if that is something that was not specifically addressed and negotiated, the way a right of first refusal works is that the current owner goes out and gets a bona fide offer from a third party, and then the town has the opportunity to match that offer. So when this came up, I believe the second time, we talked about how it might not be fair to the town to require the town to match a bona fide offer while there's a restaurant there. And so could we negotiate a change to the way in which the town could invoke its right of first refusal by paying something lower than the restaurant value? But that would have to be something negotiated between you and the property owner.
Well, in the previous time, it was stated.
Right.
It was stated. Now, the other point I wanted to make was, it just disappeared, age. age takes its
I
toll.
think you'll have plenty of time to remember before you,
What
so.
was it? Yeah, go ahead. Sorry.
Bill Taffel again on Cold Spring Road. I just would like to clarify on the space, because I think some of the things that were said were not entirely accurate. The first proposal, which came to town meeting in 2016, was for some 30-odd thousand square feet, which included a function room. That proposal was defeated by, I think, 106 to 101. The second proposal, which came in 2017, the function hall had been taken off. So, and I think the resulting square feet was 14,000 something.
25,000.
That proposal was defeated by 2-to-1 margin by like 400 to 200. So it's substantially defeated. Since that proposal, and this comes from having looked at the plant, about 1,200 square feet was taken out of the restaurant as it existed in 2017, of which 700 square feet were taken out of the basement, and 500 square feet were taken out of what was the connection to what used to be the function hall. So it wasn't actually a restaurant. So the actual size of the restaurant didn't change from 2017 to today. It did change from 2016 to 2017, but the big defeat in 2017 was the smaller number already, and it hasn't changed much since then. So,
Thank you.
and that's what it shows on the plans that are on file with the office.
Yes, and the sanitary facilities are sufficient for 600 people, by the way. So none of that has been reduced either.
Bob, do you remember?
No, I'll let it go.
All right, anybody else? Okay. Yeah. Hold on. Oh, who gets there first?
Bob Schaff, 7 Blakesville Road. I'm going to change the topic of this slightly, because I was a member of the Boston Road, not Boston Road, Route 110 Master Plan back in the late 1990s. And we've talked about this as being the gateway to Westford. And I'm going to remind people here that I believe the town shares some onus here in what happened with the fire station. I was a strong supporter of the fire station. But if you go back to the annual town meeting of 2015 and look at the presentation that fire station was sold to the town, one of the main important points was to maintain a natural vegetative buffer to Blakes Hill Road. I'm a resident on Blakes Hill Road. That's kind of a core point of what we did with the Route 110 master plan. We looked at other mechanisms to try to beautify and minimize the impact of developed properties on Westford residents and the abutting roads. We looked at structures such as stone walls to minimize the impact of lights from cars on those abutting roads. We looked at vegetative buffers. We looked at the maintenance of tree canopy. I'm kind of disappointed in where the fire station went. I'm a strong supporter of it. I argued against my neighbors. We wouldn't have an impact due to that fire station. I believed in what we were told at that town meeting 4 years ago now. I'm sitting here now coming down the hill and I'm looking at the blight that now exists across the road from us here. And I'm really looking for something that would improve this property and try to follow the guidance of this town. But at times, I don't see even the town itself following its own guidance, and it's kind of frustrating. But I really think we need to look at this as a total and not fall on false arguments that, well, it's the gateway to Westford, we can't do anything here. I kind of applaud Mr. Masaladon's efforts to try to beautify this property. I'm looking forward to an agricultural development. I'm looking forward to something that will keep some money coming into the property to maintain it into the future. I look fondly back 21 years ago when I moved here, took my children to Keith Boney's annual Halloween events. The property was a vibrant, thriving property that represented Westford at the time. Right now, that whole corner has been changed. And it's been changed for the worse. It's time to bring it back, and I think we really need to look inside ourselves as to how to do that. Thank you.
David Keel, 10 Boston Road. First off, Mark, I'd like to compliment you on the way you've run the meeting tonight. I have sat in that chair, I have dealt with those issues, and I commend you for what you're trying to do. It is a difficult thing to do, and not everybody can do it. So that's my first side. I live on Boston Road. It's nice to see all the selectmen again. I would just like to say this. I'm all for this. I've lived in the town for 41 years. I've lived on Boston Road for 24 years. I don't believe it's indicative that all the residents of Boston Road are opposed to this. Matter of fact, most of the residents that I know on Boston Road, and I'm not being disrespectful to the others that live there, most of the residents I know on Boston Road are for this as well. For years, I would go down, and I saw Keith the other day, and one of my big joys was going down and getting fresh apple cider and a cider donut down at Drew's farm with my kids. Loved it. But what you don't realize in the conversations I've had with Keith is, and I know Keith personally, is that those types of farms don't make it anymore. You can't just say, go throw a farm stand on there. Because they're all, I'm involved in financial workouts, I'm involved in financial recovery situations. I don't see it as being viable. But what I have seen is I've followed this now for a couple of years, and I went to the presentation. I would love to see a Gibbet Hill type of concept or a Forge and Vine type of concept restaurant. You know, they talk about the Gateway of Westford. Heck, I lived on an 800 square foot home when I first bought it on Boston Road. It's now much bigger, obviously. I've had 2 additions. There were people that opposed that because it was the gateway to Westford. No, you can't change that 800 square foot home. Well, change can be great. Change can be good. And I think it'll be an absolutely beautiful restaurant. He appears to be a good neighbor. He appears to be genuine. We can all, have the conversations that, I think you're lying, I don't think you're lying, but it serves no purpose. I mean, one of the things that I've heard you say is this, watch this video. Go home and watch this video, because I've done this as a member of the school committee. Watch how angry the people are coming up to the microphone. Bob Krankowitz, is he here? He's my neighbor. He's one of the best. No, he's my neighbor, one of the best guys in the world. He's my neighbor. We disagree. Bob didn't even know he was here. He's my neighbor. We disagree, but that's okay. We can disagree on this, but we don't have to get up here and scream angrily and just start waving.
Sit down.
Interesting. It was interesting how I respected everyone who was at the microphone and didn't say anything, but now I disagree with her perspective.
Please. I mean, one of the things that we're trying to do, right, is, and I agree, David, is we just need to have
conversation,
respect for each other's comments, and we're just trying to do that. So if you don't have something to add to the conversation, I would just ask that you don't, right? This is about trying to inform us about what you would like us to recommend going forward.
So, that said, I think it's a beautiful proposal. I think it would be a beautiful addition to what we all call the Gateway to Westford, and I would encourage the Board of Selectmen to support it.
Thank you.
Yeah, for the record, I didn't oppose David's house. There was a mention of the 110 master plan by Bob Schaffer. One of the key elements of the 110 master plan was to stop commercial creep. They took 495 as the boundary, and they said nothing is coming north of that except where it exists on Route 40 and the other spot villages. That was a key of what that master plan was about. What we now have is vacancies on 110, and we're invading across that line. And once commercial creep starts, it doesn't stop. It's going to come right up Boston Road. And if this proposal goes through, as I said before, I have more farmland on Boston Road that's viable. So can I do this? That's the essence of when you do a spot. I know this isn't a violation of a variance, but it is a violation of the state's zoning laws as to spot zoning, taking one thing for the benefit of one person. So if he files, I'll file.
Anybody else? Bob, you remembered?
Yep. Bob Krankowitz, what hasn't been mentioned yet, but traffic. I have enough traffic on Boston Road to handle. I don't need another 1,000, 2,000, whatever number of car trips it would be there. That's an important factor. The other thing is, that was a great idea about this. Who mentioned that? Dave? About the cider. Why don't you do the farm stand as a cider place and to sell products, and then open a restaurant on 110? Then you could use the stuff that you make, put it in that restaurant that's in a zone where it belongs. Come on, guy.
Okay. Other comments?
Yeah, one last one. I am very concerned about the liability and the long-term consequences of this. So I hope that when you're considering those points tonight, to take your vote in favor or not, and in your consideration of hopefully a 2/3 vote requirement, given that this is a change of use as admitted by Mr. Masaladon multiple times tonight. I would say I hope that you will consider that for the better of this town and for the APR program nationwide, that we secure this property and we vote no on this, and I hope that you'll consider that. Thank you.
Thanks. Anybody else? Going once, going twice? Okay. Somebody want to make any other comments from those of you? And if not, we want to make a motion of one sort of another. Yes, Scott.
So that's, to me, actually, I appreciate all discussion tonight. You know, the town 20 years ago saw a threat. They thought house lots was going to be the outcome. So the town decided to buy it, to take it out of development. This may be technically a non-change of use, but a restaurant to me sounds like development. So just from my standpoint, the town meeting has to tell me that they've changed their minds, that they don't want this to be open space anymore, that they do want something else. And if town meeting says that, then I'll abide by that. But right now, I need to hear town meeting say that 20 years ago they had one choice, and now they make a different choice.
Motion?
Sure. I will move that the Board of Selectmen not recommend Article 16.
Second.
Additional comments, questions?
Can I just make one comment? I suspect that no matter what happens on the floor of town meeting and however this goes, we are probably going to end up in some sort of legal action. I just think that we probably are. And so, as anybody who doesn't know, I think it is absolutely on an intellectual level fascinating, the discussion that we've had about whether it's 2/3 or it's majority, whether Article 97 applies or it doesn't apply. This is a release, is this a permit, is this a change of use or whatever. So on a really intellectual level, I find this fascinating, and I think ultimately it will be, if it does go to litigation, it's going to be a court who tells us what's right and what isn't right. Westford has been on the leading edge of court decisions in the past, and I think it would be fascinating if we are again on the leading edge of court decisions. And
that's one word for it, fascinating.
Again, but at the end of the day, putting aside the legal opinions right now, because Greg, as you said, I mean, we have 6 legal opinions from well-respected, well-known attorneys and secretaries of agriculture in the state of Massachusetts, and I am certainly not one here to say which one is right and which one is wrong. I don't think any of us can do that. What I think we all have to understand is, while you may agree with one opinion and not the other, all of them are well-reasoned opinions by, as I said, well-respected attorneys here in Massachusetts that need to be at least considered by everybody. But at the end of the day, it's our land, and it's the town of Westford's land, and it's the citizens' land. And it's up to us to decide what we want to do with that land. And we face whatever consequences we may face based upon our decision. The town has told me twice that they don't want a restaurant there. And so, like you, Scott, I go in with the premise that the town has told me twice already. If the town decides this time that it has changed its mind, and it may, the town may say, you know what, we're tired, as Bob Schaffer said, of looking at this piece of property. Or the town may say, you know, we're going to hang in there, we're going to see what happens. Then I will abide again by town meeting vote, because at the end of the day, it is the residents and it is all of you folks who tell us what to do and how to manage the property. So that's my statement.
So we had a motion and do we have a second?
Second.
Yeah.
Okay. Any other comments? All in favor?
Aye.
Opposed? I'm going to abstain.
What was the vote?
401.